Homeowners Bill of Rights. It sounds complicated. For a lot of our listeners, they may not want to, they don't know where to find it. They don't want to read it. If it's anything like the Obamacare Act and it's 14,000 pages long, I'm not going to read it either. Can you fill us in on the Homeowners Bill of Rights and really what is that?
Okay. There have been some really egregious practices by the banks in the foreclosure process. They will do what's called the dual track process. While you're submitting paperwork to try to apply for a loan modification, the clock is ticking towards foreclosure. And so you think that the bank is working with you, but all the time they're ready and prepared to do the foreclosure. That's definitely illegal under the new law. That's number one. And another one, of course, is if you do have a temporary loan modification, you're making some kind of payments, they can't do this, then pull the rug out from under you and say, well, we changed our minds. Those are some of the key provisions. And there's some other very important provisions in the law that require the bank to prove, in fact, they have all the paperwork, the original, the promissory note that you signed when you originated the loan, the deed of trust. They have to show the assignments of those original documents to wherever they are now. And I'm telling you, you may think I'm crazy, but they can't always produce those documents. The sloppiness of the banks, it's unimaginable. We see it all the time. And so the legislators, if you're going to take someone's property, you need to prove that you have the documentation.
Are they required to produce the original signature? Is a scanned copy okay?
A scanned copy is okay, but under the Uniform Commercial Code, they have to explain what happened to the original. And the new law says, and a very important aspect of the new law is, if they're going to go through produce documents in court, declarations, or the declaration of default that starts the foreclosure process, these documents have to be complete, they have to be accurate, they have to be credible and competent.
Now, what happens when somebody contacts you? How soon can they contact you?
Well, they can do it. I would suggest any time that the bank's given them the runaround, that they've tried themselves. We tell clients, go ahead and try yourself. If you think that you can work with the bank, if they're going to work with you, we figure there's about a 6-7% chance they'll get a loan modification. But if you've been through it 2 or 3 times submitting paperwork, they're just dragging you along, and they will foreclose. So you need to, face the music at that point. If you want to keep your home, you might want to, talk to a good foreclosure defense attorney, take them to court, and get them to do what they need to do.
Gentlemen, I need to take a quick break. When I come back, I want more on foreclosure and how to save your home. You're listening to Ledger on the Law, 790 KABC. I'll be right back.